Yes, I am, Your Lordship. Thank you for the opportunity. Before I begin on my submissions, allow me weigh in a little bit on submissions by Mr. President on the basic structure by stating that by purporting to alter the basic structure of the Constitution is like purporting to conduct a brain transplant to a patient, so that after that is done, we cannot be talking about the same patient. So once the proposals touch on the basic structure, we are not talking about the amendment anymore. We are talking about a different document altogether. Having said that, I now proceed to our petition, and the crux of our petition is interpretation of Article 257 of the Constitution to ask the court to make a determination on whether the Constitution Amendment Bill of 2020, whether it is a popular initiative or not. In doing such an interpretation, we ask the court to be guided by Article 259 of the Constitution and employ a purposive interpretation. And we rely on several authorities as listed in our list of authorities. Authority number 4, that is the Law Society of Kenya versus the Attorney General. We also rely on authority listed as number 8, the Namibian Authority of S versus Atchison. We also rely on the Ugandan case of Tinyefunza, which appears as number 17 in our list of authorities. So we ask the court to read several provisions of the Constitution, not separately, but harmoniously, so that none of them destroys the other. My Lord, we will be asking the court to look at least 5 provisions of the Constitution, beginning with Article 1, which states that sovereign power belongs to the people, and that power is to be exercised in accordance with the Constitution. Now, under Article 1, 2, that power is to be exercised either directly or through democratically elected representatives. Now, where power is to be exercised directly, Your Lordship, there is no provision for any other person to exercise that power for and on behalf of the people. It has to be the person, the people themselves, to exercise that power. There are at least 3 instances in the Constitution where the people exercise direct sovereign power without the interference or without delegating that power to any other person. One is under Article 10 of the Constitution, whereby even after delegating legislative power to state agencies, the Constitution still reserves the final word to the people through a process of public participation. So that now, before a policy is enacted, before laws are enacted, the people must be given that right to give their final word on what they think is good or bad. No one can purport to exercise that sovereign power under Article 10 for and on behalf of the people. Secondly, Your Lordship and my Lady, under Article 38 of the Constitution, on the right to vote and to make political decisions, that is an instance where the people will have to exercise direct power, and there is no other person who is allowed to exercise such power for on behalf of the people. Thirdly, my Lord and Your Lordship, under Article 257 of the Constitution, beginning with, of course, 255, 256, and 257, the power to amend the Constitution through a popular initiative is reserved exclusively for the people, direct exercise of sovereign power. Therefore, unless the people themselves are seen to exercise that power, that process from the very beginning will be an illegality, because it would amount to usurping the role that Wanjiku is supposed to exercise sovereign power. I know, Your Lordship, that you will be told much later that the people will exercise their sovereign power during the referendum. But when you look at Article 255, it talks about enacting a constitutional amendment law. It does not talk about a referendum. So what the court should be interested in is who has enacted the Constitutional Amendment Bill of 2020. Is it the people or some other entity? I am specifically interested in Article 255 of the Constitution, which says an amendment to this Constitution that does not relate to a matter specified under Clause 1 shall be enacted. So we are talking about enactment, not voting. Shall be enacted by Parliament or be by the people. So the process of enactment must begin with the people who came up with the bill itself. Then thereafter, it talks about approval of an enacted proposal to amend the Constitution. So a referendum is merely a process to approve a process that has been enacted by the people themselves. Having said that, the totality of the evidence that has been presented by the petitioners in this petition and other petitions is that what we have is neither a parliamentary initiative nor a popular initiative. For if it were a popular initiative, it ought to have been enacted. And I keep on repeating the word enacting, because that is framing of the bill itself must be by the people, by dint of Article 255 3B. It is the people who are supposed to enact, not Parliament, not any other entity. We have brought evidence in this court to show that the idea to amend the Constitution was conceived by the President, who is an elected representative of the people. The establishment of the defunct BBI task force was done by the President himself. The terms of references were framed by the executive, a representative of the people. The report itself was presented to the President. Needless to say, Your Lordship and my lady, that he who pays the piper calls the tune. So this is a bill by none other than the President. Going back to the provisions of Article 1 of the Constitution, can then an elected representative of the people purport to exercise direct power for and on behalf of the people? Because that is exactly what is happening here. The answer is a straight no. So once the court is satisfied that indeed these proposals to the amendment originated from an elected representative of the people, then that disqualifies that as a popular initiative. It cannot be a popular initiative. And the reason why the people have been given, and you note, Your Lordship, sorry, that the only instance where the people have reserved legislative authority to themselves is when it comes to matters to amend the Constitution. In all other instances, they have delegated and donated that power to the legislature. But when it comes to amending the Constitution, they reserve that right to have a say, so that either you do it through a parliamentary initiative or you do a process that is devoid of the legislature and front a constitutional amendment process. It is for that reason, Your Lordship, when you look keenly at Article 257, the legislature, especially Senate and National Assembly, have only a ceremonial role in a popular initiative process, so that whether they reject it or not, it will still have to go to the people where it first came from for them to approve it in a referendum. Now, in this instance, the bill is neither a parliamentary initiative nor a popular initiative. It is a strange phenomenon in our Constitution. It must be declared as such. Having said that, Your Lordship, allow me move to the next issue. That is whether IEBC is capable of exercising their powers under Article 257, that is to receive, verify, and approve the Constitutional Amendment Bill in the prevailing circumstances. Now, the Commission has argued, Your Lordship and my Lordship, that the Constitution does not specifically require them or place any obligation upon them to ascertain or to verify the authenticity of the signatures. The argument is that they are supposed to simply ascertain whether the bill has been supported by at least 1 million registered voters. At paragraph 28 of their submissions, they argue that worldwide there are two procedures that are acceptable to conduct such a verification. One is by publishing a list of the people who are purported to have endorsed the initiative. And number two, to make the promoters swear affidavits confirming that all the signatures were obtained willingly without any form of coercion. Now, interestingly, Your Lordship, IEBC has not told us if they have employed any of the two worldly acceptable methodologies. Even if they had done that, and that has been captured in our further affidavit sworn by Miroro Waweru, talking about the affidavit sworn on 23rd February 2021, on 21st of February, IEBC purported to have published a list of people who had endorsed the initiative, and they gave until the 25th of the same month, 3 days away, for anyone to have confirmed in writing whether their signature might have been obtained through fraudulent or coercion or without their consent. Now, Your Lordship, the 21st was a Thursday, and we have 2 days which are a weekend, Saturday and Sunday. And come Monday, you expect a population of over 20 million registered voters to have gone through 1 million signatures, 1 million lists of names purported to have supported the initiative, raise their complaints in writing, and have them addressed by 25th of the same month, close of business. In our view, that was just an attempt to cover up the iniquities because it was not practical. It was not meant to achieve the desired results of people genuinely making those complaints. That evidence is captured in the affidavit of Merodo Waweru. Your Lordship, that affidavit also shows how the following day on 26th, having closed the opportunity for verification at 5 p.m. on 25th, the following day on 26th, the bill had already been presented to the county assemblies. If then, using their own words, that one of the processes of ascertaining whether the bill has been supported by 1 million signatures is to post a list, the question that we ask is that, was that reasonable time to enable them ascertain? And the answer again is a big no. Your Lordship, we have also taken issue with the manner in which this whole process has been hurried through from the time much obliged, Your Lordship. We have taken all right, Your Lordship. Thank you. I hope you can hear me now. Yes. Your Lordship, we put a lot of reliance on the place of our constitution in this country. And the process of amending a constitution is not like amending a statute or enacting a statute. Therefore, the people must be at the center of this whole process. Where there is evidence that there is a hand of the executive that is very keen on passing through the process in a very hurried manner, then the court must pause and ask itself, why are the people not being given an opportunity? We have raised issues with the manner in which the signatures were collected. The 7 days deadline that was given is not provided by any statute or the Constitution. In our view, it was not reasonable for even the endorsers themselves to go through the bill and endorse the process, having been informed of its contents. The hurried manner in which the bill was considered by the county assemblies without any proper public participation. We have cited a case in point of Siaya County, which passed the bill within 2 days of receipt from IBC, and one wonders if there would have been any meaningful public participation in that process. So we submit, Your Lordship and Your Lordship, that this whole process is very clandestine in nature, and unless the same is declared unconstitutional, we will have a problem. Now, why am I saying we'll have a problem, Your Lordship and my Lordship? When you look at the provisions of Article 2 of our Constitution, they say that, the Constitution says that the provisions of our Constitution, and I'm talking about Article 2(3), the validity of or legality of the Constitution is not subject to challenge by or before any court. Now, the danger is, as opposed to other statutes or bills that are enacted by Parliament, once we have the President assenting to this bill, it becomes law. Not just the law, but the Constitution. Meaning that we cannot come before you again by dint of Article 2 to challenge any of the procedures, any of the provisions therein, because Article 2 comes to play. That's why the court must rise to the occasion at this moment, because we are not even sure, Your Lordship, whether we'll even head to a referendum. The President, in his opinion, under Article 257, might actually decide that there are no provisions under Article 255 that require us to go for a referendum. So what if the President signs this bill and becomes law, not just law, but the Constitution? It means we cannot challenge the procedure, we cannot challenge any of the provisions. That is the danger that we are facing. And that is actually more dangerous because we are not even sure what is contained in that bill. You heard the petitioners who came second saying that the bill that was presented in Bomas 1 was different from what was unveiled. We are not even sure which bill has been now presented to Parliament, because there has been no proper public participation, there has been no clarity, there has been no transparency. So if the President then is to sign that bill, we will have a whole new constitution which we can do nothing about. That would be a sorry day for this country. That's why we are asking this court to give meaning to Article 257 and clearly issue orders that unless the people have been involved in the enactment from the very beginning, then what we have is not a popular initiative, it is something different. I think that is all, Your Lordship, for now, unless you have any questions for myself. I've addressed almost everything.